Welcome back. This is Philip Bickle of Legal Tyranny. It's June 30th, 2021. We're going to pick back up on my reply brief, and we're starting Part C of the argument section. Appellee avoids admitting that Judge Udovic scheduled a bench trial without any charges being entered or an arraignment held against the appellant. Whoops. The appellee refuses to acknowledge that the record on appeal shows that no plea was entered by myself or the court at the time that Judge Udovic scheduled a bench trial to be held on March 2nd, 2017. Make sure we've got our site in there. And also, the docket has some of this info on there. This might actually be a docket. Yeah. Okay. As it has been admitted by the appellee in the answer brief, there were no charges entered at the December 15, 2016 hearing. My argument regarding the violation of my right to due process by not being informed of the nature and cause of the proceedings against me is entirely clear in the opening brief. The appellee makes argument in bad faith and ought to be subject to sanctions for repeatedly doing so. Call him out. Call him out. And if you made your argument very clear in the opening brief, you don't need to reiterate things too many times. Just make sure the major points are raised again, just in case you have somebody else reading things, like you have a team working on stuff and you want to make sure everybody comes in contact with the important points. Okay, so moving on. Part D. Appellee fails to acknowledge and address Part E of the opening brief. The appellee leaves a glaring omission by failing to answer to the issue presented in Part E of the opening brief. Judges Freitas and Udovic erred by failing to acknowledge that only a licensed prosecutor may initiate prosecution for a criminal case, and a police officer is not a prosecuting officer. This is a due process violation. The failure of the appellee to address this issue speaks volumes, and the support for my arguments are in the opening brief under Section E and throughout this reply brief, along with the record on appeal, number 107, written argument for trial at pages 10 through 13. Okay, this might be a little bit of a lengthier section, but I think we can make it through here. Part G. Appellee disingenuously reframed the reasons given for bias and prejudice by the appellant as various procedural actions the court judges took, to which he objected. Appellee fails to address the intentional, knowing, and willful actions by the judges which deprived appellant of the right to fair hearings and proceedings before impartial judges. Okay, the appellee fails to address the fact that Judge Freitas ignored my multiple objections to being arraigned on January 4, 2018, on the grounds that the statute of limitations had expired. There isn't anything appellee can argue to show otherwise. In the first instance, Bickle, you've already passed the statute of limitations for when he's allowed to arraign me. That was back on the day of the alleged offense. Court, once you, Bickle, November. Court, you filed your motion to dismiss. Bickle, I don't initiate anything. They are supposed to initiate. Court, okay. Bickle, prosecution. Do you guys see why the judge is not supposed to interrupt you, and everybody, is supposed to be polite and take turns in speaking? He's the first one to cut me off here. I was speaking nonstop through this as he cut me off, and I was hoping he would stop, but he didn't. So we'll try to make it through this. It is very choppy, but that's an important point. When we get to the end here, I'm going to talk about that point in my brief. Okay, prosecution. Court, Did they file the motion to dismiss, or did you? Bickle, that's irrelevant. I was heated at that point. If they filed a motion to dismiss, we wouldn't be there, obviously. He was just, I don't know, he was running interference, and it was definitely, he had me sidetracked in it. I would attribute a lack of sleep as one of the things that kept me from being on my toes there. Okay, did they file the motion to dismiss, or did you? Bickle, that's irrelevant. Court, no, it's not. Bickle, they have to. Court, no, it's not. Bickle, initiate. Court, it's not irrelevant. Bickle, they have to. A comes before B. Who filed the motion to dismiss, you or them? A comes before B. Initiation of prosecution precedes the conference of jurisdiction to the court. And he cuts me off again. So he finished saying his question there, but I was making a point which he understood very well. He wanted me off of that point. He didn't want to deal with A. He wanted to deal with B. That's irregular process, though. B comes after A. So I'll let you guys read this yourself. It's kind of schizophrenic, bouncing back and forth like that. Anyways, let's see. Well, I'm not going to continue to argue with you over this or have this discussion. Well, you're just ignoring my statements. So the judge clearly cut me off mid-sentence during my objection and kept trying to redirect my attention and argument away from the fact that the prosecutor had failed to initiate prosecution by entering oral charges within the statute of limitations as required per Hawaii Rules of Penal Procedure, Rules 5B1 and 2 and 7A. I had the right to be heard, and the judge had a duty to allow me to be heard. The Hawaii Revised Code of Judicial Conduct, Rule 2.6a, is mandatory. A judge shall accord to every person who has a legal interest in a proceeding, or that person's lawyer, the right to be heard according to law. I raised the issue again moments later when the judge tried to push forward with the arraignment, and again he belligerently ignored me to avoid this failure of the prosecutor to initiate prosecution within the statute of limitations. Bickle, you guys passed the statute of limitations. Court, okay, then at this time what I'll do is I'll note your representation and the fact that you don't want to enter a plea as to the arraignment. So at this time, the court's going to enter your not guilty pleas as to the arraignment. I'm court of the charges. So, yeah. This can't be argued against. He flat out ignored me. My raising of the issue of the statute of limitations precedes having to enter a plea. That issue has to be addressed before a plea is entered. So he completely did not address it at that hearing in 2018. And it was willful. He could hear me perfectly fine. This is willful, intentional, and knowing behavior on the part of that judge. The appellee avoids addressing this because one doesn't even need to be a lawyer to see that the judge openly ran interference by ignoring me and changing the topic from a serious jurisdictional issue, and in doing so engaged in obvious bias against me. The official court video of this interaction is impossible for anyone to watch without seeing how I was openly being ignored with bias and prejudice by Judge Udovic. Selectively ignoring a party on issues that benefit that party cannot possibly be construed as anything other than bias. And this was in relation to an issue that affected my right to be heard, to have fair proceedings, and to have the statute of limitations considered and applied. Right to impartial judge adheres in due process clause of Hawaii Constitution, Nalui v. Nalui, or is that Nalui v. Nalui? I don't know. Maybe if you're from a big island or you're local, spell out how I should be pronouncing this. Alright, we can wrap this up. Conclusion. Reversal is required based on pervasive judicial bias and prejudice, prosecutorial misconduct, and a failure to perform duties. The due process violations resulting from the failure of the prosecutors to enter sufficient charges in an ordinary language devoid of terms of art within the statute of limitations, the failure of the prosecutors and the judge to follow well-established law. It is a long list of due process violations that have been laid out in the opening brief and in this reply brief. Defendant Appellant respectfully requests that this court, 1. Order that the April 12, 2019 judgment entered by Judge Harry Freitas of the District Court of the Third Circuit be reversed. Okay, so that winds this one down. Let me know what you guys think about this material. Is there anything new to you? These issues where they're not entering charges within statute of limitations or never entering charges is just let me know where everybody's kind of falling on a spectrum with relationship to the material here. And as always, if you're not subscribed, subscribe and select the notification tab to know when I've released something else, and give the video a thumbs up if the information was useful, and please manually share this. Cut and paste links. Please share it, because YouTube just isn't enough, and we got to get this out there for other people to benefit. Alright, until next time.